The class action lawsuit against Logan Paul over CryptoZoo and that potential alleged scam of a crypto game that never came to fruition was dismissed. And for a lot of people, including Logan, that sounded like, okay, that's it. I mean, Logan Paul won the case then, except that's not quite what's going on. As a matter of fact, he's getting tried yet again for that same thing very soon here, if not right now. I think it's important to set the record straight or give some more context so that people who aren't as in the loop have a better understanding of what's going on, because Logan and his lawyer have been a bit deceptive with how they've explained what's been going on. Before we get started, of course, if you're new here, consider subscribing, giving this video a like, or screw the like. If you see the hype thing, I'm not sure exactly where it is, but if you could hype the video, I'm pretty sure that helps it more than a like, so consider doing that. But regardless of if you do either of those things, thank you for watching. Now, the origin point for hearing about this started with TMZ, where they did an interview with his lawyer, and they revealed that the class action was dismissed, which is true. In tandem with that, Logan had put out a video called "They Sued Me and Lost 27 Times," where he included a clip from his wedding where his lawyer or someone that understood or knew what was going on went and shared the news that the case was dismissed. The way that Logan explains it in this video, the way that it's described on the TMZ article, a lot of people, and me included, were kind of under the assumption that something like this usually happens and then you don't get to get tried again. The basic understanding of law is like, if you're tried of something, you're found guilty or not guilty, oh, hello, socks, you don't end up going to trial about it again. Or maybe that's just me and I'm projecting a bit, but I think that was a general assumption, and that would end up getting refuted by a couple of people. Number one, the one that I know pretty well, I've been keeping up about this case through them, is Legal Bites. She has been doing fantastic coverage of the Logan Paul, CoffeeZilla, like defamation case, as well as this class action lawsuit. And this is the video that opened my eyes as to what was actually going on. They lied to you about Logan Paul's CryptoZoo class action dismissal. She takes the first half of the video and just kind of rips apart the TMZ article and the fact that they didn't do really any follow-up, research into the case to better understand what was actually going on. They just spoke with Logan Paul's lawyer and just kind of went with it. But that leads into her giving a really good explanation as to what is going on and what this dismissal actually means.
Let's talk about what the report and recommendation and the order adopting it actually says and actually means. To start, let me give you a little bit of background about what a motion to dismiss is and what kind of holding that the judge can and will give for that kind of motion. When the judge is analyzing a motion to dismiss, what they're looking for is whether the complaint has been sufficiently pled. That means things like, does it have all the elements of each claim that they're alleging? Do they have enough specific facts that are alleged? Can the judge understand the story of what happened based on what the plaintiff alleged in that complaint? Is this even the type of harm that the plaintiff can sue someone for? Note that these are all legal questions, not questions of fact. The judge is not interested in proving any of these facts or weighing any of these facts or determining how likely or reasonable any of these facts might be. In fact, when analyzing a motion to dismiss, the court actually assumes that all facts alleged by the plaintiff are true and looks to whether legally these claims can hold up in these circumstances. The reason for that is because it's the job of the jury to weigh these facts and to determine what actually is more or less likely to be true.
I think my interpretation of what she's saying is correct, but forgive me if not. There's any lawyers that can correct me, but from how I understand it, the judge doing a dismissal here is not indicative of it being true or false, the claims being that he scammed these people or anything that had to do with CryptoZoo. The judgment comes simply from understanding legally, like within the confines of the legal system, were they able to present a case that could go to trial and actually kind of stand on its own two legs, effectively making sure that the defendants, when they're, filing their motion, all these things are filing their claim, crossing their T's, dotting their I's, so to speak. The jury is going to decide whether, it's one way or the other, if there was scamming or not. And don't get me wrong, I think this information is useful to have, but her following point is the much more interesting one for me. The dismissal of this case, or the points in it, is not to completely shut down the case and move on. It's to allow the defendants to rewrite and make their case stronger.
And that leads me to another important detail about the dismissed claims that TMZ and Paul's lawyer completely missed in this article. It's really important for me to note that of the 27 claims against Paul, all of them were dismissed. However, 26 of them were dismissed without prejudice and only one was dismissed with prejudice. And the one that was dismissed with prejudice was under the Commodity Exchange Act. And arguably one of the lesser claims in this particular lawsuit. So what this effectively means is that this report and recommendation serves potentially different functions for the plaintiffs and for the defendant. For the defendant, of course, this means he got his claims dismissed. And yeah, as of this moment, these claims are not active against Logan Paul, and it's up to the plaintiffs to come back and refile these 26 claims and to make enough changes that they will be able to survive another motion to dismiss that he probably will file after that. But for the plaintiffs, this report and recommendation actually serves as a detailed guide or set of instructions for exactly how the plaintiffs need to cure the complaint if they decide to come back with another amended complaint. And I've talked about this before. When it comes to litigation, if you are the really weak, sometimes it's a good idea to attack it and make it go away. But sometimes, by filing a motion to dismiss and getting that dismissal, all you end up doing is strengthening the plaintiff's claims. That's because you give them an opportunity to spot the weaknesses in their claims at a very early stage and to sharpen those claims as a result.
So as she said, yes, you can do this and hope that the people kind of just drop it and move on, or in this case, they also could respond back by filing down and honing in on the claims that they're making and bring it back and have that case be that much stronger after they deal with it. And you're kind of sat there with, well, are they actually going to follow up and make those corrections and continue on? And they did. Now, this video comes from attorney Tom, and apparently they are working on this lawsuit, this class action lawsuit, and they say as much, and they reaffirm that, yes, we are indeed like continuing on with this lawsuit. It was dismissed, but they're coming back and they have corrected their claims and are going back in.
My name's Tom Kirker, one of the lawyers suing Logan Paul, and I'm here to tell you that as of right now, the CryptoZoo lawsuit is active. We have amended our complaint to include new evidence. And in today's video, I want to tell you the 5 things I want you to know about the CryptoZoo lawsuit.
He does end up going into detail about these things. I'll leave a link to this video as well as Legal Bytes stuff down in the description. And speaking of, this is Legal Bytes' second video going into detail talking about it. And in her opinion, this was done very well. They go into explaining what some of the points are. They have to prove that he was actually like coercing them by whatever he was saying in advertising to end up purchasing, you know, CryptoZoo, like the crypto coin or anything like that. And it gets into talking about puffery and what that means. And she does a much better job of explaining it. Again, check out her video. She goes much more in depth, but I just want to include some of the parts that were included by the defense in response to having to make these changes. And they include this new evidence to kind of get Logan Paul and point out that these things are actually damaging and actually convince them to buy in.
Now let's look at these individual statements that show up in the second amended complaint. First, they expand on Paul's statement about the game being a fun game that can make you money. Specifically, they said that on August 18th, 2021, Logan Paul said this.
It's so fun. It provides a yield with a token, can earn you money. And
they explained that this was a material misrepresentation because it falsely represented that the CryptoZoo NFTs had a built-in mechanism to generate income or yield for purchasers. But in reality, they say the verified smart contract code on the blockchain contained no such functionality. Second, they alleged that on, once again, August 18th, 2021, Logan Paul also said this.
We have a massive team behind it and are probably out of pocket like $1 million just because we believe it's going to work.
And here the plaintiffs explain that this is a material misrepresentation because Logan Paul falsely represented that CryptoZoo was backed by a massive team and that he was out of pocket like $1 million, creating the illusion that the project was heavily funded and professionally staffed.
Now she goes into it in a lot more detail talking about, you know, essentially they have to try to convince the judge and help them understand where some of these material examples of him genuinely having an influence on their decision making here. They have to explain that to the judge because the judge might not be super aware of how a crypto program or an idea like this would function and what would constitute as something that would actually convince someone to purchase or buy into the product. They also pointed out that Logan Paul had lied about the art that they had done for the animals. Like you can see here, we handmade art for the past 6 months, bro. Proof, very specific notes, 10 different artists making this stuff when, you know, it was elephants with butterfly wings and it was like clearly stock images put together. But my favorite one and the most interesting kind of gotcha gotcha here is that they called out Logan Paul on the fact that he lied about the developers' kids being addicted to playing the game. And so he said this, but then later on, he admitted to the fact that he knew a month before he said any of that, that there was no functional game to play. There was no CryptoZoo game to play for kids to be addicted to, which means that he did just straight up lie about it.
The final statement that was alleged by the plaintiffs in the second amended complaint, and in my opinion, this one is a real doozy. Here, they said that, once again, on August 18th, 2021, Logan Paul said the following.
Project, a development team that has to be wizards because you're dealing with blockchain, people's money, transactions, and it's going to be on the Binance Smart Chain. Just I'm saying this here now because the Ethereum network, the gas fees don't make sense for the type of continuous and frequent transactions taking place in our game. It's a really fun game that makes you money. Kids are addicted to it. Our developers' kids, all of them, cannot stop playing the game.
So this apparently was a huge lie. And if you remember, this was the kind of statement that the magistrate judge said would be a material misrepresentation if the plaintiffs could clean up their allegations as to who said it and when. And well, here you have it. I mean, Paul said that developers' kids were addicted to the game, and obviously that can't be true because still to this day, it doesn't exist in any functional form. And that's what the plaintiffs explain here. They say, at the time this statement was made, no game existed. This statement was false when it was made. Paul's own cross-claims reveal that on September 8th, 2021, that's almost a month after Logan Paul made the statement to the public, by the way, Paul saw that no functional game existed, no playable build had ever been delivered, and Paul himself privately acknowledged confusion and dissatisfaction with the state of the development. Paul, therefore, could not have genuinely believed that CryptoZoo was a fun game on August 18th, 2021, because he had never played it. Additionally, he had never seen another play it because the game did not exist in any functional form at the time, and by his own later admission, no playable build had ever been delivered.
So in essence, they have just brought more and more and more evidence to support their claims that Logan was not just kind of like, hyping up the CryptoZoo game a little bit. He was apparently actively lying about it from their claims and what they're trying to provide as evidence. And the fact that we have confirmation from one of the lawyers that yes, they are going right back at it and we're, going through all the details, it's very interesting to see that they did all of this PR work to be like, yep, it's fully dismissed, we're good. And now to see this all thrown right back in their face, and it's like they're just back at square one, except their competitor and the person that they're going up against is that much stronger and ready to actually go to court. I'm very curious to hear what you guys think. Again, highly recommend you guys check out Legal Bites or follow up with some of the updates from one of the lawyers that are actively suing Logan Paul. I'll leave a link for them as well. Hope you guys enjoyed the video, and I'll see you guys later. Adios. Peace. Bye.